is the Regional Health Administrator, which is the senior federal official for public health for the U.S. Department of Health and Human Services. In this role, my team and I provide many types of resources to empower individuals to take charge of their health and wellness. I would like to welcome you to today's Google Plus Hangout, sponsored by the New York Regional Interagency Work Group of the White House Initiative on Asian American and Pacific Islanders. Today's Hangout, being held in collaboration with the New York Public Library for Science, Industry, and Business, has convened a panel of federal experts who will shed light on actions that kids, teens, young adults, and their parents can take to deal with the effects of bullying. Thousands of young people, including members of the Asian American and Pacific Islander community, are bullied each and every day. The definition for bullying is unwanted, aggressive behavior that involves a real or perceived power imbalance. This behavior can be repeated or has the potential to be repeated over time. Bullying includes such actions as making threats, spreading rumors, attacking someone, excluding someone from a group on purpose, and utilizing texting and social media for these purposes. Bullying in many communities, including the Asian American and Pacific Islander community, can be complicated by linguistic, cultural, and religious barriers. And research shows that nearly 1/3 of all school-aged children are bullied each school year, upwards of 13 million students. Students involved in bullying are more likely to have challenges in school, to abuse drugs and alcohol, and to have health and mental health issues. More than half of Asian American and Pacific Islander students who reported being bullied at school indicated that bullying occurred in the classroom. In fact, Asian American and Pacific Islander students reported the highest rate of classroom bullying, 20% higher than any race or ethnic group. During today's Hangout, you will hear information from federal staff about laws to combat bullying, how these laws are enforced, and the types of actions individuals who experience harassment and other types of bullying can take. We invite you to check out stopbullying.gov, a website developed by the U.S. Department of Health and Human Services, which has resources targeting kids, teens, young adults, parents, educators, and the community to assist with the prevention and response to bullying. The website has information on how to talk about bullying, how to prevent bullying at school, and how to develop community-wide anti-bullying strategies. I'm very excited about today's discussion, which will provide you information that you need to take a stand and be a leader to prevent bullying in your community. I will now pass this session over to our partner, Ms. Madeline Cohen, Assistant Director for the Business Library. Thank you for joining us today.
Hi, I'm really glad to participate in this workshop and glad that the library can be hosting it. We are a real partner with the community and with different agencies, all of the groups here that we're working with, to provide information and assistance in many different areas, especially with job information, financial information, and small business. Those are three big focuses for our library. And public libraries all over the country really help people with their lives, with getting things that they need, getting information they need, and finding out what they have to do to maybe start a new business if they want to get, not keep looking for a job maybe, with the unemployment situation being what it is and the recession. Many people have decided they want to start a new business, and we really help businesses get started. So we run a we run a business plan competition where we give people training to start their own business. We also provide information on people's finances. We provide help for people to get financial advice from professionals who are advisors. We work with partner groups such as the Financial Planning Association of New York, and we also work with other groups, New York City, with New York City government, which is now assisting people in getting their taxes done. April 25th, we have a full day of financial education here at the library. And by the way, we're on Madison Avenue and 34th Street, in case you don't know where we're located. And we have a full day of classes, education, advice, and seminars on April 25th from experts, including people from many of the agencies who are here right now. So we have a great event coming up, and we also have on our website a lot of information you can access from home. You don't need to come into the library. We have a small business website called at the URL smallbiz.nypl.org, and we also have financial information at moneymatterspro.nypl.org. So you can get all kinds of information. And our website, just in case you want to check us out, is nypl.org/Sybil, S-I-B-L. So I think that's my part, and I don't want to take too much more time. So thank you.
Great. I'm Lattimer. I'm with the U.S. Department of Justice Community Relations Service. We were actually created by the 1964 Civil Rights Act to work with communities dealing with conflicts based on race, color, national origin, and also violent hate crimes based on gender, gender identity, disability, religion, and sexual orientation. I'll be the moderator for this afternoon's panel, and I'm going to introduce our panelists in the order that they're going to speak. I'll give a brief selection from their biographies and also the issues that they're going to cover. So let me begin to my left, which probably is your right, Sunu P. Chandy. She's devoted her 15-year legal career to working for civil rights in the labor and employment context. She serves currently as a senior trial attorney with the United States Equal Employment Opportunity Commission, where she litigates employment discrimination cases in the public interest and works to ensure that the underserved communities are aware of the EEOC's role in creating a more just workplace. He has extensive knowledge of the federal employment discrimination statutes and has litigated civil rights in areas including race and national origin-based discrimination, sexual harassment, religious discrimination, disability, age discrimination, and retaliation. Thank you.
Thank you.
We also have Gary Kiang, who is a senior attorney with the U.S. Department of Education Office for Civil Rights. He oversees the investigation and resolution of complaints of discrimination on the basis of race, color, national origin, disability, sex, and age made against state education agencies, elementary and secondary school systems, colleges and universities, vocational schools, proprietary schools, state vocational rehabilitation agencies, libraries, and museums that receive U.S. Department of Education funds. He has conducted high-profile investigations and agency-initiated compliance reviews related to racial harassment at the elementary, secondary, and post-secondary levels, disproportionate representation of minorities in special education, and gifted and talented programs. Lara Eshkenazi is the Deputy Chief of the Civil Rights Unit at the United States Attorney's Office for the Southern District of New York. She investigates and litigates violations of various civil rights laws. Since joining the United States Attorney's Office in February 2003, she's worked on and supervised numerous cases involving violations of the Americans with Disabilities Act, the Fair Housing Act, and Civil Rights Act of 1964. So let me give you an overview of what our panelists are going to speak on. Ms. Chandy will present an overview of the United States Equal Opportunity Employment Commission, covering both the laws enforced by the Commission and how the agency serves the public through the investigation of complaints, mediation, litigation, and community outreach. She'll also present specific ways that the Commission focuses on issues that are relevant to the Asian American and Pacific Islander communities. Mr. Kiang will present information on harassing conduct in its many forms, including verbal acts and name-calling, graphic and written statements, which may include the use of cell phones or the internet, and other conduct that may be physically threatening, harmful, or humiliating. Ms. Eshkenazi will discuss the federal civil rights statutes related to combat school bullying, specifically Titles 4 and 6 of the Civil Rights Act of 1964. So if you would begin, Ms. Chandy.
Sure. Thank you so much for organizing this panel, and EEOC is very pleased to take part in this event. I'm going to start with talking about the laws that are covered by the EEOC. My colleagues will be focusing on the school setting, and I'll be focusing on the employment setting. So the name of our organization, the agency, is US EEOC, Equal Employment Opportunity Commission. So our goal is to promote a just workplace. A lot of people have concerns and issues of how they're treated in the workplace. In your first job, you may have experienced harassment in any of the forms that we've talked about. And our goal here is to explain when that's illegal and how to address it. The statutes that we enforce cover race, color, national origin, sex, religion, age, disability, and genetic information. That's probably one of the most important things to keep in mind, because there's lots and lots of unfairness in the workplace, but unless it's tied to one of those bases, it's not covered by federal law. There are city and state laws that address additional categories, so there may be additional protections, but the federal law only covers those categories. Why that's really important is because if you're being mistreated or harassed in the ways that my colleagues will discuss, it has to be tied to one of those bases to be covered by our laws. You should certainly complain to your supervisor or manager if you're facing harassment or bullying in any form, but you should also be aware of which ones are covered by the laws. The issue of retaliation is also covered. If you make a complaint because you're being harassed in the workplace because of your sex, because of your race or your color, any of those reasons I mentioned, and you make a complaint and you're fired or your hours are cut or something negative happens to you in the workplace that's substantial, that counts as retaliation under our laws. I also want to make the point that sex discrimination includes pregnancy. It can also include sexual orientation and gender identity based on how the plan works, but in New York City, we have additional protections from local laws. So discrimination includes hiring, firing, hours, anything relating to your job if you're treated in a worse way than another group based on those categories. That would be covered. And then the focus for today is bullying, which in the workplace, the term that we use is harassment. So the question is sort of how can you tell that harassment is because of one of those factors? Race, color, national origin, age, disability, gender identity. How can you tell? One way is if the comments themselves address those points. If someone talks about your race or religion in a derogatory way, in an offensive way, that's the easiest way to say, I am being harassed because of my race, because of my national origin. Another way that you can tell if a group is being discriminated against is if one group is treated better than another. If one group comes in late and they get written up and another group doesn't. Or if one group always has to, it's a fast food restaurant, one group always has to clean the bathrooms, the women always have to, or the minorities always have to. If a group is being treated differently than another group connected to one of these bases, that's another way to tell that that sort of conduct violates federal law. So if that is happening to you, you should talk to your supervisor. If the supervisor is the person who's doing that sort of conduct to you, you should go above that person to a higher manager or an HR person, or sometimes there's an 800 number listed. But it's very important that you make that known to the company so the company can address it. If the company doesn't address it, that's when you would consider coming to an agency like EEOC with a complaint. There's an 800 number, which I'll give you, 800-669-4000, which is our intake number to start the process. You can look at the website, eeoc.gov, to understand more about the laws and to learn about the charge filing process. There's a questionnaire you can use to help you figure out if the conduct you're facing fits under our laws. We do not have online charge filing, but you can do it through the mail, through the phone, or coming into a local office, and our office's information is on the website, all the local offices of the federal agency. So the way the agency works briefly is there's an enforcement unit that does the intake, investigates the claim, tries to resolve it. It could be going through the mediation process. It could be resolved through a fact-finding, sitting down with all the parties. But the charge that you file is sent to the company, and the company has to write a position statement or is given a chance to explain their side of the story. and then the investigation goes from there. It can involve on-site visits or interviews. That's what happens with the investigation. And then at some point, the agency says, we believe there's discrimination here and a cause finding, or we don't believe that that's what happened here and no cause finding. If there is a cause finding, there's a chance for the company to work it out through conciliation process. And if all of those steps happen and the case is still not resolved, you would get a notice of right to sue. So you could go to federal court and bring a complaint, or in a few instances, EEOC will bring the case in court. So the federal government is the plaintiff, is bringing this case in court in the public interest to benefit a group of people. And so I want to use the rest of my time to talk about a handful of those cases. The first group involve Asian Americans and Pacific Islanders, and the second group involves youth workers. First case, one of the first cases I handled at EEOC, this was back in 2000, was against SPC Services, and there was a man, Eddie Hang, who was complaining at the workplace because his wife, who was a cleaner at that place, wasn't getting a lot of shifts. And the individual who was in charge of that was giving a lot of shifts to individuals from her own background. I believe she was Russian, and she was giving all of those individuals a lot of shifts and not giving it to this Asian American woman. So her husband, who worked at the same place, complained about that and said, I think this is because of her background that you're not giving these shifts to her, and he was fired. So that was a very clean retaliation case because he brought up an issue covered by our laws and was fired. And that case was settled back in 2000. Another case, United Galaxy. This was someone of the Sikh faith who wore a turban and went to get a job at a Lexus dealership. And he was not hired because they said his turban violated their dress code. And he couldn't have a beard and he couldn't have a turban. And that also violates federal law because a company has to give you a reasonable accommodation to any such dress code policy. Another case was Plaza Hotel. This was right after 9/11, and there were Middle Eastern, South Asian, Arab American wait staff in the restaurants in the Plaza Hotel, and they were being called Osama and Bin Laden instead of their own names. And we had about 12 men in that case, and it settled in 2005. And very recently, we had a case, Global Horizons. First three cases were out of the New York area. The Galaxy Lexus case was in New Jersey. Global Horizons is actually out in California, and this was a very recent case in March 2014, where a group of hundreds of Thai farm workers were being abused and harassed and threatened with deportation and generally treated worse than the other farm workers. So a judge found liability, and then we'll go on to figure out the damages, the monetary damages in that case. I'm going to end with a few cases involving youth workers. Back in 2000, again, one of my first cases at EEOC, Heathcote Deli. This involved sexual harassment of teenage women working in the deli by the kitchen staff and also by the owner. And that case was settled. All these cases are settled with monetary damages and also policy changes to the company in terms of training, in terms of information given to the workers and the management about how this sort of conduct violates federal law. Next case was Home Depot. That involved someone with a mental disability, and she had a job coach. So when she had issues at that Home Depot facility, instead of calling the job coach, they fired her. And that case was important because it was a one-person case. It was a woman in her 20s, and her father brought her in, and they filed a charge. And when that went to litigation, it led to an implementation of a nationwide job coach policy at Home Depot, and it was covered by the New York Times. So then additional people called us and said, you know, my son works at the grocery store in Chicago, was one call that I got, and he has a job coach. Is that really the deal under federal law? You should have this person be there as a guide to you. And that sort of accommodation is required as long as there's no undue burden on the employer. So the employer, it has to work with you on these issues. And the last two cases, one was Carol's, the largest owner of Burger King restaurants across 13 states. That settled in 2013 for $2.5 million for 89 women across the country who were sexually harassed. In the fast food industry, this sort of thing happens quite frequently. Oftentimes the manager there is also someone in the 20s or very young and may not know these rules, and there's no one else to go to. So you should always look for an 800 number or HR department, someone to raise these issues. And the last case I'm mentioning involves actually an Asian American woman who was also a young woman, so I thought it was a good one to end with, US Dream and Dollar Store. She was being sexually harassed by a manager who was from the same South Asian community, and the owners were from the same community. So she really did not want to come forward, but when the harassment became physical, she was at home crying. Her parents, tried to ask her what was going on. She told them, and then her father brought her to a lawyer, and they came to EEOC. And she was very embarrassed to even talk about the sexual harassment, but she did, and she did a great job in her deposition, and that case was settled. And the most important thing about that case is that owner also had 40 stores. So we had training and policies and postings in all of the stores based on this one person's complaint. So the idea here is that you assert your own rights for your own benefits, but also it could also benefit many, many other people. Thank you.
Great, thank you so much, Ms. Chandy. And I'm sure when we have the open questions and answers, we'll definitely have some more questions on some of those cases. You would continue, Mr. Kiang.
Sure. The Office for Civil Rights is the office within the United States Department of Education responsible for enforcing federal civil rights laws and education programs and activities. Pursuant to Title VI of the Civil Rights Act of 1964, the Office of Civil Rights is tasked with the responsibility of investigating and resolving complaints of discrimination on the basis of race, color, or national origin. OCR also has jurisdiction of complaints alleging discrimination on the basis of sex, disability, and age. We have jurisdiction over any recipient of federal funds from the department, which, as Matthew mentioned, with the elementary and secondary schools, colleges and universities, vocational schools, state education agencies, and museums and libraries. And as Sunu mentioned, we look at bullying in terms of whether or not it constitutes harassment. In terms of harassment, harassment is a form of discrimination because it can deny or limit equal educational opportunities to the harassed student. Bullying can be harassment under Title VI if it's motivated by or because of an individual's race, color, or national origin. Harassment, unlike bullying, does not require the intent to intimidate or that the individual be the intended target of the harassment. So if you're a bystander who witnesses harassment and as a result, or they witness bullying and as a result you feel harassed, that will allow you to file a complaint with our office. I did want to mention that when you file a complaint with our office, you can do so online. You also don't need to be the injured party. If anyone can file a complaint of discrimination, we don't require a specific standing. I do also want to mention that the forms of harassment typically that we see in the education context deal with, as we mentioned, verbal abuse, such as name calling, racial slurs, and epithets. Graphic statements such as graffiti or stereotypical caricatures, hangings in effigy, or violent crimes such as physical assaults. So it runs the spectrum from name calling all the way to violence and physical assault. Harassment can actually rise to the level of being a hostile environment if it is sufficiently severe, pervasive, or persistent to interfere with or limit the ability of an individual to participate in or benefit from the services, activities, or privileges provided by a recipient. The recipient, of course, use that interchangeably with school or college or university. Harassment can be a hostile environment it doesn't require more than one incident. For example, the more severe the conduct, the less there is a need to show repeated incidents. One incident can be severe enough to constitute a racially hostile environment. Some of the factors that OCR considers when examining to determine whether or not a hostile environment exists is, for example, we'll look at the nature, again, whether it was verbal or physical. We would ask questions like, does the conduct actually bother the victim to interfere with his or her participation in the program? For instance, would a student or an athlete find that they can no longer compete on the team as a result of the harassment? The objective standard the question would be, would a reasonable person of the same age, sex, and race as the target be offended? We, unlike some of the other areas of law, education well, OCR takes a look at, and we do consider the age and the race of both the target and the alleged harasser. The scope of the alleged harassment, for example, did it involve behavior in one class, or was it something that was school-wide? In terms of frequency, we look at, again, whether it's isolated, one episodic incident, or is it part of a pattern of harassment? As far as what the pattern of harassment goes, it's important to remember that in some instances of bullying and harassment, there may not be the direct evidence that it's racially motivated. It's typically accompanied by a racial slur, a derogatory comment. It can be motivated. If you look at it, for example, if it involved the same group of students who are both the harassers and the target, that would seem to indicate that it would be part of a pattern of harassment. So if in another time there might have been evidence of that discrimination, the racial motivation or racial animus, that would also serve as proof for other incidents involving the same parties. Duration, we looked in terms of a hostile environment. Was it something that was a momentary episode, or was it something that might have lasted hours over a class period, or during the course of a basketball game, where there are racial taunts the entire game? We also look at, again, the location of the incidents. The classroom or the public area is completely different as opposed to being harassed within a dormitory or a locker room. We look at the identity and the number of the people involved, especially their relationships. If it's a person who might have some type of authority over the harassed person, that lends itself to a more severe situation. We also look at other incidents outside one specific complaint. So what we'll do in terms of an investigation, we'll ask about whether or not there have been other reports or other incidents of harassment against a particular race, and how a school or a recipient has dealt with that complaint. How have they responded? And under Title VI, what we look at is whether or not a school took prompt and effective steps, reasonably calculated to end the harassment and to prevent its reoccurrence. We look to see whether or not they provided any means of remedying the effects of the harassment, as well as preventing retaliation against the target or the complainant. The time frame in order to be an effective and a prompt response needs to be a more immediate, and basically the school is required to determine through investigation or otherwise determine what happened. The inquiry needs to be prompt, thorough, and impartial. For example, if someone's accused of being harasser, they really should have the opportunity to present their side, as well as perhaps present witnesses on their behalf. Different remedies for harassment that we've typically negotiated on the behalf of complainants. I think what people most readily associate is discipline of perpetrators. That's usually the first step, but there are several other steps along the continuum. For example, counseling the perpetrators about their hurtful effect of their conduct, as well as publicly labeling what they've done as racial harassment or bullying. It's important so that that type of conduct or those types of incidents are actually identified as racial discrimination. Whether or not it serves as an educational lesson for the community as a whole or just that particular group of students. It's also important to, in terms of remedies, to reaffirm the school's policy against discrimination. Title VI, we don't require specific written grievance procedures for Title VI, but many schools do have basically procedures for complaining about discrimination, under which they typically include race, color, and national origin. We'll also look in terms of remedy, providing counseling to the alleged victim. In addition, if they were denied access to an educational program or activity, or their academics were affected, they might, an appropriate remedy might be academic services such as tutoring. Certainly, allowing a student to change their class should be a remedy. And with respect to changing classes, if it's a student who makes a complaint of racial harassment, it's important to know that they shouldn't be the ones to have to change their class to accommodate a harasser who wants to keep the same schedule. Typically, we'll find that the school will try to address the problem simply by moving the complainant or the student or the complainant to another class, and of course that disrupts, that can disrupt the whole learning process, especially if it's later on in the school year or if it affects their ability to schedule other classes.
I definitely think we want to pick up when we have the question and answer is the retaliation, which I think you were starting to get in towards the end of your presentation. Right. I mean, in terms of retaliation, just by engaging in protected activity, you're basically advocating on any of your rights under Title VI. So if a recipient takes a retaliatory action against you, such as some type of adverse action, you have a right to file a complaint with our office specifically. So regardless of whether or not there turns out to be an actual hostile environment or act of harassment, if someone has asserted their rights under Title VI, they're protected from retaliation. Great, thank you. Thank you.
Hi, so I'm here to talk about what we've been doing from the U.S. Attorney's Office. My jurisdiction is the Southern District of New York, which includes Manhattan and the Bronx and some northern areas of New York going through Dutchess County. But also the Department of Justice has an education opportunity section, and they also do work all over the country on these issues. Where we come in is generally if there's a broad pattern and practice of discrimination that's not being addressed by the school sufficiently. In our district, we actually haven't had a lot of those cases, although we recently had one where we filed a brief that I'll talk about in a minute. But generally, there are three provisions of the Civil Rights Act of 1964. Title VI, which Gary already spoke to you about. Title IV. Title IV is a provision that was traditionally used to desegregate schools. But it's broader than Title VI in that it's not limited to just race and national origin. It would also cover sex and religion. And so that's a bit of a broader, and that's something that can be used to address pervasive problems where school districts are just not addressing pervasive bullying that's going on. Title VI, as previously mentioned, covers race and national origin. I just want to mention, though, that in some areas we would interpret national origin to include religion based on the type of discrimination that's going on. And there's a brief that we filed against Pine Bush School District. We filed a statement of interest. We're not a party to that case, but we filed a statement of interest arguing that the anti-Semitic acts that were very pervasive in that district amounted to a violation of Title VI if those allegations are true. So that's just some way that we can expand on Title VI's coverage. It really depends on the type. You have to look very specifically. It's a very fact-based inquiry to determine whether the religious discrimination would fall under Title VI. I also want to mention Title IX, which prohibits discrimination based on a denial of equal protection. And that's where a lot of gender cases could be brought. One of the issues there is that could also potentially cover any harassment based on sexual orientation. Specifically, if it's based on gender stereotyping, then we would argue that some sexual orientation harassment would fall under Title IX. And that's a provision that could be very useful. That's a big problem in a lot of districts and can be used to address that. But again, we would only come in and we work with the Department of Education and have frequent communications with them when we find a pervasive problem that's going on in the district, and we try to address that. I also briefly want to mention Title II of the ADA, which provides that state and local government have to provide services in a way that does not discriminate against people with disabilities. So there could be potential, if there's a bullying problem going on against, let's say, students in New York City public schools, for example, based on their disability, and that's not being addressed, Title II could be used to address that problem. So that's another area that we can get into. And like I said, I mean, luckily in New York we haven't had many of these cases, but the Department of Justice does do these cases all over the country. Complaints can be filed online at the Department of Justice website. We also have in the Southern District of New York our own website with a civil rights complaint form that can be filled out if these issues come up. And like I said, we also keep in frequent contact with the Department of Education to find out if there are cases where they're learning that this is broader, this is bigger than we thought, and whether we can help out and get involved in that way. We're very open to doing that.
Great, thank you so much. I think now we can take some questions from the Hangout. If we can have folks type in their questions, that'd be great. Okay, while we're waiting, I did have one question for Sunu. I know one of the things that you talked about were youth and young employees. And I was wondering, in terms of, we have students coming out of school who are going to be working during the summer. If they do have, a complaint, is that something that they necessarily would take to the EEOC, and depending on how long they're at the job, are there any provisions or any limitations on?
No, it covers all workers, part-time, full-time, and I actually wanted to make the point that you have 300 days to bring a complaint. So if you're in a state that also has state laws that cover the same area, if not, you only have 180 days. So that's something to keep in mind. It's not, you don't have to do it too soon, but if you wait too long, then you're just time barred from bringing the complaint. But it's very important to raise the issue at the company level first, because the way the law has developed in this area is that if a company has a very good equal employment opportunity policy with many avenues of complaint and details about what you should do if this happens to you, and then you don't follow those steps, then you try to bring a charge or you go to court, and a court will say, well, this company was very proactive in this area, and so shouldn't be held liable. Now, if you bring the complaint and they investigate and it's not handled in a way that's effective, then you, of course, could go ahead with your complaint. But the companies do have a right to have notice about what's happening. Now, there are exceptions to that. If you can say, my friend complained and then she got fired, then it makes sense. You have a very good basis for saying, I didn't bring the complaint. Now, that basis cannot just be, I was too scared to do so, because everyone that I talked about in every one of these cases was too scared to bring a complaint. But if the procedures are there, you should follow them before going to an agency. That's the steps you should take.
Great. Sunu, there's an add-on question as well.
Oh, this is an issue that's particularly relevant for people, for students in school, college or graduate school. Do the laws also apply to internships?
Yeah, I think there's new sort of laws on that, and just recently that's a change that's come up, but it does apply to interns as well. I have to. I'm sorry?
Unpaid volunteer work?
I mean, if you're getting credit for that, I think there's going to be a question about, and maybe that the Department of Ed could answer that. I think sometimes the status is, are you there as a student or are you there as an employee? There can be some unclear lines, but there should be protection if you're getting credit and not paid. Is that right?
Right. That's fact specific. So if in that instance you're getting credit and not getting paid, that would lend itself to being more of a program or activity by the college or university, in which case they would be responsible for ensuring that you have, a work environment free of racial harassment. And if So at the very least, again, if you may not have a complaint with the EOC, then we would get that through referrals.
Right. I mean, this happened years ago with the workfare issue, where a lot of the places said, well, it's not a workplace because we're not paying them the traditional way. But then we looked at Title IX and different ways to address that, and ultimately it was addressed as something that's covered by the law. So.
Thank you. One question I had for Gary. You talked about graphic images and the like. One thing that's come up a few times over the last couple of years are Confederate flags and other similar images. And I was wondering if you could talk a little bit more about that in terms of bullying versus First Amendment, so on and so forth.
Well, in terms of the issue of Confederate flags, and we do, OCR has the general stance that when we look at any type of conduct that might implicate First Amendment rights, the goal is really not to curtail any speech. But as far as Confederate flags or any type of other graphic evidence, if it goes to speak towards the harassment being based on race or color or national origin, yes. In of itself, again, it's fact specific. We would look at it in terms of totality of the circumstances, how was it being used, what age was the alleged targets. So it varies again. Because our jurisdiction requires that it be based on racial animus. If the flag itself wasn't being used in that type of situation, I think we would immediately preclude taking it, but that's something we have to consider.
Okay.
Can I ask a question about Department of Education? Do you ever see mediation used or community sort of methods versus the discipline, and also other ways that there's sort of an interface with the criminal justice system if students are expelled? Is that something that you see? Sort of what are the recommended approaches to handling the sort of conflict in the schools?
Yeah, we're definitely, it's definitely an area that's gaining recent attention in terms of disparity, racial disparity in discipline. Mm-hmm. But as far as mediation, one thing we do offer through our office is mediation. If a party, including class complaints, feels that there's a Title VI issue, what we'll do is bring the parties to the table, whether it's the complainant or the students, the school or the college, and really try to work out an effective resolution rather than simply proceeding right to investigation. At times, in fact, more often than not, recipients really do want to know how to respond appropriately, but they really may not necessarily have the expertise, in which case we also offer technical assistance, where we're, unlike an investigation, we can speak in broad terms, we can definitely answer any type of questions that recipients have, or it could be parents or members of the community.
Great, thank you both for that. And one thing I wanted to ask Lara, in terms of looking at Title IX and gender identity, I know one of the issues that we're seeing a lot are transgender youth and unisex bathrooms, whether or not students who identify as male or female based on on physical characteristics can use either one of the two of the restrooms. Could you talk a little bit more about that?
Yeah, I mean, I can't speak for obviously the whole Department of Justice position on that. I'm just going to speak my personal opinion on that. But it's something that we've looked at, and we haven't had the opportunity to bring a case like that. But I think from our research and our position would be that discrimination, allowing them, not saying that someone can't use a bathroom based on the gender that they identify with, would be discrimination based on gender stereotyping, which we think would fall under Title IX. And unless they had a real justifiable reason for doing that, I think we would take the position that that is a violation of Title IX. But again, we haven't tested that theory yet in our district. I'm not sure it's been tested in other districts yet either, but I think it's one that we would test if given the opportunity.
Yeah, I mean, EEOC just about a year and a half ago.
Okay, similar to that.
Yeah, we have taken a position as an agency that if someone is discriminated against based on trans identity, that would be covered under Title VII as sex discrimination. That would be because of sex. And we've had cases, at least in the federal sector, that have been decided on that basis.
Thank you both. And do we have any questions from the Hangout?
Well, we have one question which was posted regarding a father and daughter, and he basically states that she had been receiving racial slurs from her basketball team, and the way that the school handled it, they personally didn't feel it was appropriate, and he was looking for institutions that they could turn to for some sort of assistance and guidance in addressing this issue.
Yeah, I specifically did saw that comment, and I believe that this gentleman actually he had someone represent him who was part of a nonprofit organization, and that person on their behalf filed a complaint with our office and justice. So it was something that did go through our resolution process. And I mean, I can't speak as the specifics. It wasn't filed necessarily with our region, but I do know that there was reached.
I guess we could also open it up to any further questions from the audience that is seated behind us. We had an add-on to one of the other questions, but if there are any other questions, why don't we take an opportunity to have some of those asked right now.
Are there any resources available to students now to learn about what their rights are for each of your agencies?
Sure, as far as education, go to ed.gov and look at OCR reading room. There are a number of publications for a variety of audiences that provide information about a school's obligations under Title VI. And that would include, again, what we've spoken about today, ways of addressing, resolving, remedying harassment, and places where you can go to complain if, for instance, that you're being harassed, but it's not, under a basis that OCR has jurisdiction.
Where did you find that information? Can you give us a URL for some?
Sure, I can have that posted, but the easiest way for anyone who's looking for a specific type of question is definitely just going to ed.gov and typing OCR in any of the specific area that you have the question in. It's very user friendly, and I know that a recent addition is they're working on adding posting a database of our actual recent cases, so that if people need reference, they can see resolutions that we've actually acquired for recent claims.
And EEOC, we have a program called Youth at Work, and it's www.youth.eeoc.gov. And there are a lot of brochures and materials targeted to young people that can be printed out, or if you contact our agency, we can mail you some, and they're sort of quizzes and different sort of interactive features. So www.youth.eeoc.gov. It says the 411 on your job rights, and the program's called Youth at Work.
And similarly, Department of Justice, go to www.doj.gov and you search for the Educational Opportunity section. There's a lot of law there. You can also go to www.ada.gov if you're concerned about harassment based on disability. That has all the disability laws there. I don't know we do have an office website too. I don't remember the URL off the top of my head, but if you Google United States Attorney's Office for the Southern District of New York, we also have a website that has some resources there as well.
Excellent.
We have another question.
Yep.
It states, do these apply only to public schools, or is there a different set of procedures when dealing with private schools?
What does this question indicate which level? Elementary, secondary, post-secondary? At the post-secondary level, almost every institution is covered by our jurisdiction because federal aid in terms of student financial aid, that basically triggers an institution's responsibilities to comply with federal civil rights laws. At the public school level, all public schools certainly. At the elementary level, all public schools certainly. Schools that typically that are private, unless they're state-sponsored and they have a grant, most likely we probably don't have jurisdiction. But again, that's really something that's fact-specific as to whether or not this is a program that's being operated by a recipient versus let's say a secular school.
So most all colleges and universities are covered because they receive financial aid, but some lower level schools, if they're private, they're not.
That's right.
Unless they get a federal grant of some kind.
Was there another question? Second question?
Yeah, I was curious about women in sports. You mentioned that, Laura. Are there sort of cases or investigations that either of you can talk about in terms of the resources given to women's sports versus men's sports? I'm curious about how that's developed in recent times.
Sure. Title IX, collegiate athletics. I believe there's approximately 75 open compliance reviews across the country. And I know, for instance, there are a number in our area that are currently actually both under at the collegiate and the secondary levels. And that there's also, it includes the range of not only Division I schools, but Division II and Division III schools. So it's something that's that we do actively investigate.
Still a big issue.
Yes.
We have two last questions. One is, the first one, are there preventative steps students can take to stop bullying before it begins?
Yeah, absolutely. One of the things that we mentioned in our guidance is to, if you have grievance procedures or if you have a policy against non-discrimination, to publish that so that everyone is aware, students as well as teachers and staff, that there's basically an investigation process and a complaint process in place. Again, also it's always a good idea to offer racial harassment training. Taking a proactive stance rather than waiting for the harassment to occur. As far as that would also probably lend itself. I know we've done this with a number of districts. We've offered technical assistance. They're looking for age-appropriate materials about racial harassment. It could be with preschoolers, and they'll want to know, well, how would we teach, them to recognize what racial harassment is, and so that's something we'll develop specifically for that audience.
And I think similar to the workplace, we always look for leadership from the top, and I think if the heads of schools, the principals, are they devoting resources to this? Do they have a staff person who's devoted to diversity issues and anti-discrimination? It shows that an organization, whether it be private or public or employment or school, cares about this and is taking steps to address it. And I think those are some of the ways we see proactive prevention.
We have one last question before we wrap up, and it's a case-specific question. I attend country college. AP exams are given college credit, but AP Chinese is denied because the Chinese department denies them credit because they believe Chinese students will be getting easy credit. This is only AP Chinese.
So courses, the main courses are assigned and given credit.
I mean, just first blush on its face, I would definitely file a complaint with our office. We'd have to get some more information, but again, it's to discriminate in terms of foreign language. It can be used as a proxy for national origin. So in that case, that's certainly what it appears to be.
And how would they file the complaint?
They would file online, or at least go online to ed.gov, OCR. There's an online complaint form. It's very easy to fill out. You'll get it instantly. You'll get an email response right away, or you can do it the old-fashioned way, pen and paper, and mail it in. Either way, we'll respond to you within 30 days.
Why don't we close with that? If both of you could also just reiterate the complaint processes for your offices.
If you go to the website for United States Attorney's Office for the Southern District of New York, we have a civil rights section under there, and there is a complaint form in there. Or you can also go to doj.gov to the civil rights section, and there are complaint forms available there as well.
And for EEOC, you can call the intake number 800-669-4000, but would recommend going to eeoc.gov to look at a questionnaire to see if your complaint would fit under our federal laws.
Excellent. I want to thank all of you for participating in this panel, and I think we'll have a transcription of this, or actually a recorded version of this available later, and we'll send out to folks who are interested in that, as well as additional information on each of our presenters and also the websites that they outline. Great, thank you so much, and have a good afternoon.